But there's no.
No. Certainly that becomes a question. But to say I was overly concerned about that, here's what I have, counsel. I have his phone at the scene where this body is.
This is case number 24F3-0955, the people of the state of Michigan versus Fareed George Hayar. Am I pronouncing your last name correctly, sir?
Hajar, yes, sir.
Hajar. Okay.
Your Honor, good afternoon. Ryan Murad, PA 3665.
Yes, Your Honor. Jessica Blanche on behalf of the people.
Counsel, how do you wish to proceed?
Your Honor, with regard to the arraignment, we waive formal reading. Mr. Hajar stands mute.
All right. So ordered. Now, Ms. Blanche, I'd like to hear from you on this one. I've read the bond recommendation, and I'm kind of interested in what you have to say here.
Sure, Your Honor. We're asking for a $10 million bond in this case. We're also asking for a home confinement tether on release. The victim was found deceased in Northfield Township. Defendant took her body from Dearborn and dumped it in that township. Not only did he not report her death, but while family and friends were reaching out to find out what happened, he gave them misinformation, and the body wasn't discovered for about a week after he dumped it in Northfield Township. This is an ongoing homicide investigation. There's serious concerns for the community. The defendant frequently travels outside the United States. We're asking that he does not travel outside of Michigan or the United States. We're asking for him to tender over his passport. I think it's already in police custody, but we'd like to keep it while the pending of this case is in place. We're asking for all standard bond conditions, drug testing if he is released to home confinement tether. And I believe that's it, Judge. Thank you so much.
All right, thank you. Mr. Murad, what do you have to say?
Judge, a whole lot. I'd like to tell you that Mr. Hajar is a 57-year-old resident here in the state of Michigan. He's a single father of 2 children. They all reside with him, along with his 87-year-old mother that is literally under his care. When visiting his house, I met with his mother, his sister, her husband, and his children. He has a plethora of family support on this particular matter. Additionally, I'd advise that he has 26 years of employment at the same job where he's the IT director for. He has absolutely no prior criminal convictions other than an operating while intoxicated offense, no assaultive criminal convictions, no capious history whatsoever that I'm aware of. I believe he's a model citizen, Judge. He's earned his PhD from Wayne State University. He's also earned his master's degree from Lawrence Tech, and he's also the president of Professional. Again, there's no capious history. He has a whole community supporting him in these allegations. And Your Honor, when I go through MCR 6.106 Section F, I think between A and I, every single one of those factors points to a personal recognizance bond for my client. Now, I understand that these charges are serious. And I think that in order to issue a cash bond here, the court's required to determine that a non-cash means won't be sufficient. And I can tell
what I have to determine. Counsel, I know what I have to determine. Thank you.
Thank you, Your Honor. I would only add here.
Okay, go ahead.
I'm sorry, Your Honor. I would only add here that my client has retained counsel and will surrender his passport. We have no objection to any GPS monitoring device, but I would ask the court for a reasonable bond in this particular matter. And he's not been charged with homicide, and it's been over 70 and a half hours since his arrest.
All right. Ms. Blanche, your reason for the very high bond request was that the defendant poses a danger to the community. Can you explain that? I mean, is there some indication here that he's involved in the death? Because what the complaint says is he disposed of a dead body and perhaps chopped up a dead body.
Well, the last time the victim is seen in this case is entering his home. She never left his home. And then you see him driving to our community where the body is dumped. His car is seen on video. His phone location is where the dump site is. And then after that, we discover her body. So the fact that she's last seen going in his house, she never comes out of his house, then he misleads police, family. During all of this, yes, Your Honor, there's huge concern here for what happened.
All right, thank you. Mr. Murad, anything else?
No, Judge, I think we've laid it all on the record.
All right.
Just no
Okay,
objection to
thank you.
tether.
All right. Bond is set at $2 million cash or surety. The defendant, in the event that he posts bond, is to give up his passport, and he may not leave the state. And in the event that he is able to post bond at the $2 million cash or surety level, he is to be confined to his home with a home confinement tether. The probable cause conference in this matter is set for July 25th at 9 o'clock in the morning. Does that work for you, counsel?
I'll make it work regardless, Judge.
All right. Okay. Thank you. Anything further?
If I may.
All right. Thank you both.
Judge, I'm sorry, if I may.
Hang on for 1 second. Mr. Murad, did you want to add something?
Yes, please. Can you hear me?
I'm
Your Honor?
sorry. Yeah, it's like sitting in a barrel in here with the noise. So go ahead.
Sorry, Judge. I would just only ask the court to consider reduction of what it's already ordered, only because I don't see that anything has been placed on the record that my client is a flight risk, won't appear, or has had any violent history. The court rule is clear on this, Judge. I'd ask for a reduction.
That's why I asked Ms. Blanche, and she satisfied me that there is a potential danger to the community. All right.
Thank you.
Thank you.
You may be seated. And I'm just going to give an admonishment. I'm not making any accusations or anything. There are a number of people in the courtroom. Any outburst, anything will not be tolerated. You will be removed. If you keep giving me problems, you'll be taken into custody. And there'll be no questions asked. I hope everybody is understanding.
I think everybody understands.
Court does call the case of the People versus Fareed. Is it Hajar?
Good afternoon, Your Honor. The court please Mark Krieg on behalf of Mr. Hajar.
And Ryan Murad, PA 3665, on behalf of Mr. Hajar, stands present to my right. Sir, please introduce yourself to this honorable court.
My name is Fareed Hajar.
All right.
I would give my P number, but I don't want anyone knowing how old I am.
They didn't have them then, did they, sir? No. Everybody knew each other.
My partner, he started when there was no P.
Got it. All right. This is your motion. He can have a seat.
Thank you, sir. I have filed a brief, but I have some supplemental information. Your Honor, I understand, and I did listen to the bond hearing, that there is an active homicide investigation going on. I spoke to Mr. Surma at the Wayne County Prosecutor's Office, who is overseeing that investigation. And I've spoken to Ms. Blanche, and she agrees. Here were the representations. The cause of death has not been determined. The investigation is open. There is no timetable as to when that will be completed. And it's not even clear at this stage that there is a homicide associated with the body that was found. I indicated that he is a longstanding member of the community. He has lived in this country for over 40 years, over 40 years. He served in the military and the Marines, and I have a picture, Your Honor, that verifies his service in Marines at Desert Storm. To say that he has community support is a gross understatement. Present, I'll just give a number of people who would vouch for his credibility, for his desire to appear at all of the cases to defend himself on these charges. First is Oscar Garza. Would you stand up, Mr. Garza? Mr. Garza is a retired Detroit police officer. He was a sergeant in the K-9 unit. He has known Mr. Hajar for approximately 40 years, has known him since high school. He has never known him to be violent. He has one prior misdemeanor from 2012. That's a DWI, which he received probation and successfully completed probation. I don't know if the court had an opportunity. I did give the court the URL for the Zoom hearing on all that.
I review all of them whenever I have a motion, so I'd seen it.
Okay, so all he said was he has, quote, the potential for violence. Outside of this offense, there's no history of violence. If he's charged with murder down the road, which certainly is an open question. So, when you're charged, you're presumed to be innocent. You would assume even more so when you're not charged. and that bond can be appropriate. Judge, I'm not asking here for a personal bond, although quite frankly, under the court rules, I don't think a personal bond would be out of order. I'm asking for a $100,000 10% bond with a GPS tether. He can only go to work, to medical appointments, and religious services. I think that is an absolutely reasonable bond. There's no history of flight. If the court has questions, I'd be happy to answer
Well,
them.
in terms of the coordination, because this stretches over 2 counties, and you indicated that you talked to somebody from Wayne County.
Correct. As
And maybe Ms. Blanche will answer this, so I was holding off in terms of the question. In terms of the murder investigation, as well as the potential charges, who would have those?
They would be our jurisdiction. So I
Got
don't know why Wayne County would say that it's their jurisdiction, because we actually sat down and had a briefing with Wayne County Prosecutor's Office, Dearborn Police, Northfield. They were present. The body is located in our jurisdiction. So if we can't prove exactly where, let's say it comes back as strangulation or something, it happened on the high, I mean, the jurisdiction would be where the body is.
Body
So
is,
right now,
correct.
we have jurisdiction. If we do declare homicide, it is going to be in our jurisdiction right now. But obviously we are not there yet, but this is an ongoing active investigation.
Well,
And I-
not just so that you know, and I sorry to interrupt you there, but that's why when you said about Wayne County, I was curious, because it would seem to me that, at least from the sketchy facts that I know, that it would be here unless there was something else.
If-
Would be here.
May I, Your Honor, and I
Yes.
can expand upon that a little bit. We've spoken, and I think she would agree with what I'm about to represent to the court. Wayne County is also involved in the case because they don't know where she died. And we don't know whether it's a homicide. But I spoke to Ms. Blanche, and she agrees that it's an open investigation. No charge has been brought. There's no timetable, and they have not even, at this point, determined that homicide is the cause or the manner of death. To hold this man on a $2 million cash or surety bond without even know whether it's a homicide and under what circumstances, I think is antithetical to everything that this country stands for, that someone's presumed innocent. He has not been charged. If he's charged, then whether it be in Wayne or Washtenaw County, then the court can set a bond that it believes appropriate for a murder, depending on whether the proof is evident or the presumption, great. But the $2 million cash bond on offenses that theoretically the guidelines are 0 to 17 at best, and like I said, at worst 19 to 38 seems to me to be a violation of the 8th Amendment and the Michigan Constitution. If the court has questions, I'd be more than happy to answer, but I don't think I've made any representations today that Ms. Blanche would disagree with in terms of the homicide investigation.
Well, besides, I didn't want to get into the autopsy or what has been conducted so far because it isn't relevant to the charges yet, correct?
Right.
But the fact that he's making these representations in court, the medical examiners are medical examiner in our jurisdiction, and she did say that the circumstances are consistent with homicidal violence. That is, last time I talked to her, she's still waiting for the toxicology. It's pending. We won't know cause and manner until after that is done, and she wants to, hold off on drafting the autopsy protocol. But that is all we have right now in terms of whether or not this is a homicide. Obviously, it's still being investigated, but I'd like to speak just now based on the charges when I can on why I would like the bond to continue as it is.
And if, Your Honor, homicide charges are brought, I will make sure he surrenders himself.
Yeah, but counsel, if I were to have that preliminary finding, and I realize it's not a finding, but that this is consistent with homicide, then I have what was, at least from the documents filed by the parties, that there is some connection there. Why wouldn't I take that into account? I mean, what would be inappropriate, I guess, with the court taking that into account?
What I think would be inappropriate is that he hasn't been charged and he's presumed to be innocent. But let's assume that you can take it in. I think a $2 million cash or surety bond is still excessive. I mean, I'm not, like I said, I'm not asking for a personal bond. I'm not asking him.
Yeah, but counsel, what I'm getting at is you're indicating to me that there's no determination that it's a homicide.
I was not aware that there was a preliminary finding.
Right. I understand. I'm not saying that you're trying to misrepresent anything to the court. That by no means am I saying that. What I'm indicating, though, is that you want me to take into account sort of the absence of something where there's something going on and I now have something else, but you don't want me to take that into account. And I don't know that courts operate that way.
Okay. So let's take that into account. Then I think a $500,000 10% bond would be reasonable, but a $2 million cash or surety bond, it's no bond at all. And even on a homicide, bond may be denied. There's a recent Supreme Court case, bond may be denied where the proof is evident of the presumption great, but does not necessarily have to be denied. You can get a bond on a murder case where the proof is evident and the presumption great. It's permissive as to whether you remand somebody. But on the charges that he's facing now, he's entitled by the Constitution, both of Michigan and the United States, to a reasonable bond. And for a case, so
I'm hearing you, but I'm just saying the idea of what's going to be a reasonable bond is in a lot of ways also, you certainly laid out the factors in your brief, but it's also the circumstances and sort of context that I'm operating in as to what the reasonableness of that bond is.
Okay.
I mean, certainly that has to be taken into account. This becomes a different type of case in certain respects because there is this ongoing piece of it.
if the court does not feel my suggestion of $100,000 10% bond is reasonable, then the court can set some other bond. But 2 million cash or surety, no 10%, I just think is far excessive, given that what he's facing now carries, under the guidelines, in worst case scenario, 19 to 38 months.
Okay. And I'll certainly let Ms. Blunt argue, but one of the things that I'm to understand is that there is, so a couple of things. One, that there may have been misrepresentations as to the knowledge of the individual to the police by the defendant.
That's been an accusation. I have not seen any discovery yet, so I can't speak to that. I've been told that there was a false exculpatory statement made. I'm aware of it.
Correct. And also phone tracking data. So, and my point to that is this, and I don't know how much of the discovery you've seen, what you've seen, or
none.
not. If you're telling me you haven't seen any, then I don't know what I necessarily do with that. But as I'm to gather from this, were this a circumstance of he knew the person or saw the person, saw with the person, nothing else sort of connects them there, and then the person a week later is found dead? I certainly get your point. I don't think that's what I have here, which places this, at least for me, in a different posture. Because and I'll certainly let Ms. Blanche give the argument and the information to the court on that. But from what I gather here, I have, I think, his phone in the township, in Northfield Township. I have, so he sort of tracked to where the body is.
That's my understanding.
And
The
also,
bond hearing.
well, right, but then also that there is video where the defendant is in the presence of the decedent in this case. So it certainly, I'm not operating in the vacuum you like for me to operate in, because I think I've got something wholly different here. Now, there may be other explanations for it ultimately down the road. I'm not making that type of finding, but I can't leave that out and just ignore it either.
Okay. I get that, Your Honor. That's why I'm saying if the court doesn't feel $100,000, 10% is a reasonable bond, then the court has a variety about the $500,000 10% bond, $1 million 10% bond, but a $2 million cash or surety bond is no bond at all.
Your Honor, I would just argue that the factors that the court's relying on, what's been placed on the record, I still don't think is a nexus with a homicide charge. I think with count 1 and count 2, that's what the court's laying on the record here, is that if someone was allegedly found in a certain area, but there's been nothing placed on the record that tells us there's a certain dispute or certain violent tendency, certain behavior that my client is responsible for this. That has not been laid on the record. What's been laid on the record here is supporting evidence for count 1 and count 2 of this charge, not of any unrelated charge. There's been nothing before us that said that there was some sort of issue.
Counsel, let me just stop you there for a moment, because there's a bit of a problem here.
Why is that?
Because yes, that's what you're dealing with at this point, but I think that goes to then ignore the fact that there is this continuing investigation into a homicide, and then with the information, just the brief information that was presented by the people, that what they're, at least the medical examiner, is seeing is something consistent with a homicide. So, and I'll let you finish your argument, but I want to make sure that you understand how I'm seeing some of this, and that is, if on the surface of it something is consistent with a homicide, and then I have not just the defendant in the presence of that person, but then I have tracking data that would place him in the township near the body, I'm looking at something totally different. I get what you're saying in terms of the charges, but that becomes problematic, I think, from the court in terms of the setting of the bond and release conditions, because this is something that is fluid. So go ahead.
And also, just to finish off, Judge, I don't see that anything's been placed on the record, despite everything that's been placed on the record, that a GPS tether, any sort of confinement provision with that 100,000 10% would not be sufficient to protect any community. I mean, he's hired attorneys. He's going to be confined to his home. He's going to have to put up money. I mean, we have almost this entire community here behind us. We have his 87-year-old mother who lives with him, who he's caring for. He has his 2 children. I mean, his ex-wife. I've never seen an ex-wife come and support any of my clients, Your Honor, in court. So I think we have the community.
You just don't know the good ex-wives. Go ahead.
My ex-wife came to my
I don't know.
My ex-wife came to my second wedding.
And just to finish this off, Judge,
Yes.
I'm not sure how many times the court hears this, but I've met with Mr. Hajar. I've met with his lovely family. I really, really think that this is an amazing person. I think he's going to adhere to any of your conditions. I understand that there's a serious situation going on, but as it relates to bond, I don't think that anything's been placed that tells us he's going to violate a confinement provision or that he won't surrender his passport. He's willing to do all of this, Judge. And we have no problem with him doing this confined to his home and paying at least $10,000. But I'd ask the court to just keep that in consideration when ruling on bond.
Ms. Blanche.
Judge, obviously the victim is deceased in this case. This was called in as a missing person. Her last phone location was at the defendant's house. They went to go question the defendant. He said he doesn't know who this person was. And then they started gathering his coordinates of his phone along with video. And based on the video, the victim's last seen going into his house, she never leaves. His car I think it's early in the morning, you see his car lights come on, off, and then you don't see the defendant leave his home until later the day when he tracks up to Northfield Township, and her body is located in the place that his phone coordinates and his car. There's video, different places up in Northfield Township where he's roaming around, and her body is then discovered a week later. So she's last seen going in his home, she never leaves, and then her body is recovered a week later up in Northfield Township. I think there's huge grave concern for the community safety. He's been dishonest with police. He acted like he didn't know her. Then he said, oh wait, yeah, I do know her. She was at my house, but she left earlier in the morning. So there is concern for police safety, and the fact that on the records in place, well, how do we, a GPS tether would be sufficient here? That GPS tether would tether him to the home that this allegedly took place at. The fact that we have a missing person that was last seen in his house. So we have a GPS tether at that house with also, he lives with his mom and his kids, who his mom, I believe, was present at that time. So you have witnesses, possible witnesses, that haven't come forward to the police or even been honest in this, and we want to tether him to that house. Judge, I'm sorry, but there's a huge issue and huge community safety based on misrepresentations by this defendant, and then also the circumstances surrounding this case. So no, I'm asking you to continue the bond, the $2 million bond. I believe it's reasonable under the circumstances. I was asking for a $10 million bond. If this was a homicide, I would ask you to deny bond. But we are asking for a bond. We're not asking you to deny bond. That's not appropriate under the court rules. The $2 million, yes, according to community safety, I believe it is. It is.
Just briefly, Your Honor, if the court thinks he shouldn't reside at his own home, maybe we can make arrangements that he could live with one of his friends, his brother, or a close friend. So there was a Detroit police officer who's known him since high school. I'm not saying, Your Honor, again, I don't want the court to misunderstand my argument. I am not saying that you shouldn't at all take the homicide investigation into consideration. What I am saying is, even if you take it into consideration, he hasn't been charged with it, and a $2 million bond is no bond at all. I mean, if you wanted to go to a bail bondsman, you'd have a $200,000 premium that would be non-refundable. They don't have that kind of money. So again, maybe he can raise some money with friends and family. He's obviously got a lot of support, but it ought to be some kind of a reasonable 10% bond. That's all what I'm asking.
But Counsel, you would agree that the reasonableness, I mean, one of the things that you're arguing to the court is that he's not a danger to the community. Correct? I mean,
No.
go ahead.
I don't think that's not the standard. The standard is, are there reasonable conditions that can assure
It's a
the
huge
safety?
factor.
It
Counsel.
is.
I mean, that's a huge factor.
It's an important factor. There's no question. But the question are there conditions that can be imposed that would mitigate that danger to the community? Nobody can say anybody is never a danger to the community unless, possession of.
Okay, but Counsel, maybe you're not following what I'm saying. What I'm saying is this. If on the one hand, and I just hypothetically place an extreme out there of, I guess the extreme would be, in my mind, what the prosecutors laid out in terms of the woman goes into the house, she never comes out. He is seen leaving. We have his phone then in Northfield Township. We have her phone at his house, so we know that they're at some point together. That's one extreme. If on the other extreme, I just have, she was at his house, but at some point she left, her phone is someplace else or goes someplace else, and then something may have intervened that happened differently. You'd want me to take that into consideration in terms of setting bond, because that would cut against him being a danger.
I don't want the court to think that I don't think that danger to the community is not a relevant factor. I hear the court completely. I've been doing this for 44 years, and I get where the court is coming from. My point isn't that danger to the community shouldn't be considered. My point is that the bond that is set is unreasonable. And you can consider in determining what the appropriate bond is. It doesn't need to be a $2 million cash or surety bond.
Maybe you
A $2 million 10%
maybe
bond.
you agree or disagree with this, but the reasonableness, especially if I were just using the one factor of danger to the community, the reasonableness of that bond that I may set is certainly going to be dependent in some way with the risk that I see.
Correct.
Right?
I agree with that.
So it really requires me to sort of analyze what's there and what risk is there. I never forgetting he's presumed to be innocent. I'm not saying that, but just in terms of the risk of what evidence is there. I'm having a difficulty here at this particular moment because I don't want to, I want a full fair hearing for anybody that comes before me. When you indicate to me that you haven't seen the discovery in some of the stuff that's coming out, and I'm not saying anybody's playing any games, I'm not saying any of that. I would just like the full-fledged argument. There may be a reason, if true, and I have no reason to doubt it, that her phone tracks to his house, which may be inconsistent with statements that he's given. There may be some reason for it. Where I'm at right now, and I understand why you brought the motion when you did, but where I'm at right now is that gets put out there. I don't have anything on the other side of that. And there may be, and it may be unfair for me to be looking from you if you haven't seen even the preliminary parts of the discovery.
The only thing I know is what I listened to at the arraignment and the bond hearing at the arraignment. But let's assume let's say this was a murder, which it's not at this stage, and the cause and manner of death have not definitively been determined. I think a $2 million 10% bond would be reasonable. So what I'm saying is the court should not have to punish him and make him pay a premium of $200,000 that is not refundable. So make it a 10% bond, Your Honor.
I don't think this court gets in the business of punishing people with bonds. We just don't.
But again,
But counsel, some people, sometimes the prosecutor thinks maybe the court's being too lenient or letting people go because of the bonds that we've set. Then there's defense attorneys that get all upset with us saying we're trying to punish people by the bonds that were set. I can tell you every judicial officer in this court, and I know certainly for me, I'm looking at a number of different factors. I rely upon counsel to give me all of those factors. I factor in all of the things that you pointed out. Factor in, is this person going to be a danger to the community? Is there a way that I can, given the circumstances of what's going on, safely release this person into the community and the like? I go through that whole analysis.
can I throw something out to the court that I think...
Can I stop you? Probably not.
You probably
go ahead.
If you told me no, I would keep my mouth shut. I can tell you that. I've learned. Judge, the difference between a $2 million cash or surety bond and a $2 million 10% bond, the only difference is either way he has to put up $200,000. Either way he has to put up, but one is refundable and one is not. And even the $200,000 10% bond, the court keeps $20,000 of that for administrative costs. So all I'm saying is, Judge, if you're going to make him post $200,000, if he shows up, which is certainly isn't chump change, $200,000, that is a significant bond, and he forfeits it if he violates it in any way. And if the court feels that he should live with his brother, who would ask as a third-party custodian, so be it. But I'm asking, Your Honor, that all I'm saying is, even when you consider the homicide investigation, that a $2 million cash or surety bond is excessive. That's my argument, Your Honor. And whether...
Well, you just said two things to me, because I'm trying to figure out, and I want to make sure I'm getting your point. I understand you're saying that it's excessive. You're also making the argument, I think, that even if the net dollar amount's the same, that when all's said and done, somebody, whoever would put that up, would like to get some of it back.
Well, the bail bondsman doesn't get it back.
Oh, I know. I am aware of that.
But also, the difference is that he could possibly raise $200,000 with the understanding that he's going to show up. These people trust him. They would loan him the money. But with a bail bondsman, he'll never see it again. And nor will the friends and family that are willing to chip in to post the bond. He does not have $200,000. I mean, I've been doing this for 44 years, shown this kind of support at a bond hearing, ever. I mean, he's got strong ties with the community. He served his country honorably, put his life on the line in Iraq.
Counsel, I'm not disputing any of that.
I know you.
That's what it is. I also realize I have people who may have led great lives, that when one's looking at it, they've led great lives, that all of a sudden something happens. Don't know what, maybe nothing happens, but all of a sudden something's in front of me that something has happened. And at that point, I have to sort of weigh and balance and try to determine what would be appropriate to have this person released.
Understood.
If I have someone who on one hand met somebody that night and then somehow or another through what nothing that really connects them has ends up deceased someplace in the field or wherever, that's one thing. If I have someone who, and I'm not saying this is his case, lured somebody into a house and then all of a sudden kills them and then it takes them out and then dumps them into a field, those things on the surface can look the same, but it's a very different risk analysis in terms of what bond I set to then let somebody into the community.
I understand. Again, I'm not asking for some.
No, I know, counsel, and I might.
But I think his 57 years should count for something, just as a homicide investigation should.
It does. His service to this country, it counts. The support, everything counts. It's a balancing for me. I appreciate the support that's come. I appreciate all the letters, everything that I've seen. All of those are things for this court to weigh. But there's something going on the other side of the scale, too. I can't just take that and say, okay, well, this is it. There's something on the other side of the scale, which the people have pointed out. And the problem, counsel, and this is where I want fairness, is that those things that the people are putting forth, I don't have a I'm not hearing a counter from you. I'm not looking for you to give me your whole case.
No,
I'm not looking for you to do all of that. All I'm saying is what the people have laid out, quite frankly, is some pretty damning things if those allegations are there. And I'm not hearing an answer. I'm not saying that I won't have an answer, but I'm not hearing an answer. And I think the reason I'm not hearing an answer or even some suggestion of an answer is because the discovery hasn't been seen.
My answer wasn't going to be on the merits of the facts of the case. My answer was going to be, the court said, yes, his life does count for something. And
absolutely.
So if that counts for something, and the homicide investigation also counts for something, which clearly this court believes, and I'm not going to challenge that at this stage. So they both count for something. So they both count for something. There's somewhere in between a $2 million cash or surety bond and a personal bond.
Well,
because
that's funny, counsel, because what I would really be arguing in between is what their original request was, which was a $10 million and a personal. So I'm not here to just pick a number. That's not what it is for me.
I understand that.
It's not, setting bond is not a science, it's an art.
Right.
So it's tough to do.
Right. I'm not trying to beat a dead horse, Your Honor. All I'm asking is that the $2 million bond, he simply cannot make. So if the court made it 10%, there'd be if he can raise that, then he'd have to raise $200,000, which is certainly, as I said, not chump change. It's a significant bond. And I think given that he has not been charged with a homicide, but considering that that's something that is in your calculus, that's a fair and reasonable bond. That's my argument, Judge. And given his long life history that anyone would be proud of up until these charges, that is worth something. And what it's worth, in my estimation, is a reduction of the current bond.
Counsel, let me ask you. Okay. I have her phone tracked to his house.
Correct.
I have his phone track to the location of her body, what would you have me do with that? I'm not saying any of that can necessarily be proved, but what would you have when you're talking about me doing the calculus? What do I do with that?
You consider that down the road, perhaps there could be homicide charges of some sort, whether it be murder or manslaughter, and that be taken into consideration and is a factor. But there are also other factors that I think can assure conditions or combination of conditions, meaning tether, passport, third-party custodian, that will assure the safety of the community.
I'm wondering whether or not you would agree with that if you saw at least the preliminary discovery.
What, a $2 million bond?
Well,
I would.
with something other than what you placed in your motion. And I don't know, counsel, and I'm not trying to put you on the spot in that. I'm just saying,
If and when he's charged with a homicide, he could be remanded.
But counsel, let's say it's not even the homicide charge. But I have those factors all in the charges what I have now. That's a huge risk.
Anytime someone is released on bond, there is a risk, Judge.
Yes, but counsel, there are different cases.
That's
And
right.
if I have some woman who has disappeared, who ends up dead, who the phones are at the same places, and then within the course of that investigation, I have someone that you want me to let out to say, trust him that he will do this, and I look at his life, I also have that other part that he's been deceptive throughout the investigation. All of that's got to play in.
Yes, if you want to take that into consideration, I understand that. My argument, Your Honor, is that if there's going to be a $2 million bond, it ought to at least be a 10% bond. And that, I think, is a reasonable bond. I've seen homicide cases, murder cases that I've done in my 44 years, and I've done nothing but criminal defense my entire career, where I've seen in homicide cases bonds far less than a $2 million 10%, where there's significant evidence. So what I'm saying, Your Honor, is what's reasonable. And what I'm arguing is a bond that one can't make is not reasonable. I don't want to lose credibility with the court, so I get the message clear. It's come through clear that the bond I've requested is not in the cards. But I think to have this bond where it's at and just make it a 10% bond where the same $200,000 is posted is reasonable and fair, taking into the facts in his life.
So counsel, if I set it at $500,000, 10%.
I don't think that's $500,000, Judge.
Oh, I can do math. Yeah, I get it.
That's. Can I speak with the family for a minute, Your Honor?
See, this is the issue, because he's saying this is not a reasonable bond, but he also in the same breath says it would be reasonable if it wasn't a surety so they could get the money back. So we can bring them, we can provide the money to release him, but we want it back, so that's why it's unreasonable. So he does have access to the funds clearly to be able to actually pay the bond. So in this whole reasonable thing, there's no case law that counsel has applied to this court saying that this bond that's been set by the magistrate was unreasonable from the start. So at this point, Judge, I don't think the magistrate was acting outside its authority unless there's some law that can be provided. But based on the circumstances and the argument, I don't know how you are unreasonable at this point. Now it's just whether or not how we're going to pay for the bond.
Judge, my law is the 8th Amendment to the United States Constitution that buy-in should not be excessive.
I will give you time to talk with the family. I'll take a recess.
Thank you.
Let you know.
All right.
Thank you for giving me the opportunity to talk to the family. There's 2 points that I thought of that well, the first is Ms. Blanchard was kind enough to forward.
Ms. Blanche, you mean?
But did I say Ms. Blanche? I'm sorry.
Yeah, you made her like the ex-governor.
The ex-governor.
I don't know. Go ahead.
Anyway, she was kind enough to forward me the email that she got from the medical examiner.
Okay.
And what it says, yes, it does say a skeletal trauma, and it says a skeletal trauma analysis will be performed this month. Toxicology is pending. The circumstances are consistent with homicidal violence, but the body may not give a definitive cause. So it would seem to me, Your Honor, that if there was blunt force trauma, that would have been seen immediately to the skull. And I don't know what she means by the circumstances, but
Counsel, I think we need your client.
Oh, I'm sorry.
No, you just broke into argument. I'm
Okay.
thinking he probably should be here for this.
Shall I go get him?
No, you can go get him, but they'll probably keep you.
Okay.
No, you can't get him. Go ahead, counsel.
Okay. Again, Ms. Blanche was kind enough to forward me the email she received from the medical examiner. And it says the body may not give a definitive cause. And it says toxicology is pending. I mean, this could have been an overdose. We just don't know. But what to me is important is that the skull she was able to examine, and there's no statement in here that it was the result of any kind of blunt force trauma. The second thing I wanted to make a point of, which I think is really, I thought about this after the court granted us a recess for me to talk to the family. I think on one level, having to borrow money from friends and family is more a guarantee of an appearance than if you paid a bail bondsman, because this is his family, and he'd be letting down his friends and family that are willing to post the bond because they have faith in him. I don't know that I really fully understood, or at least I thought I did, but did the court ask about a $500,000 10% or $5 million?
Well, you were making the argument about getting money back and the like, and sort of balancing that against the something to guarantee his presence. And at least in my mind, that's what I was
certainly,
and so that's what I put that out there as you were arguing about the payment of the $200,000.
Anyway, if the court was inclined to raise the bond to something higher than $200,000 with a 10% provision, that would certainly be less onerous than a $200,000 cash bond. The bond I suggested, which the court obviously doesn't agree with, I thought was reasonable, but even it's going to be difficult. They don't know whether they can post a $500,000 10% bond. They would certainly try, but I think they could post a $2 million 10% bond. So with that being said,
that they could post a $2 million if it were
it would take some. Pardon?
If it were 10%,
Yes.
it could be posted.
Yes, the family they think they could gather enough money from friends and family to post that kind of a bond. And like I said, I think it is more of an assurance if he's indebted to his friends and family than to a bail bondsman who he has no connection with. And I given, that they may never be able to tell the cause of death, and certainly I understand where the court's coming from, that this could be a homicide. And if it is, then obviously the bond may change, but it's not there yet. And, in this country, we are presumed to be innocent. So I think the $200,000
Counsel, believe me,
I know you do.
that is not,
You just are worried about
it
the
is
danger.
not lost on the court.
I know.
That whole concept is not lost on the court.
Okay.
But what also is not lost on the court is the other pieces that are there that aren't necessarily being argued. I understand it hasn't been charged. I also understand that people can't charge a case until they have enough there to charge. But
But I've conceded,
it's the
Judge.
fluid nature of the information that is causing the court some consternation, because I have an event. We pretty much know everything about that event and we're done. What I have here is we have an event of some type. we're not even sure what that event necessarily was, but we see some of the manifestations of it. And then there are pieces filling in, like the phones.
Right.
And those kinds of things that.
I get it. And Judge, I want you to understand this. When I made this bond suggestion, if it had been in a vacuum and there was no evidence that this could be a homicide, I would have not asked for a $100,000 10% bond. I would have asked for a lower bond. So it wasn't like it was lost on me.
No, I know.
You know, that's why I didn't ask for a personal bond, because I do understand how the court might want to consider that there's an open homicide investigation. But again, my point is not that it's irrelevant, because I don't think it's irrelevant, and I don't think I've ever suggested that it's irrelevant. But what I do think is that it's relevant, but so is the life that he has lived that anybody would be proud of up until this point. And so again, if it's a $2 million 10% bond, the family thinks they could raise that. If the court thinks that a higher bond of a 10% is necessary, obviously we have to defer to the court.
Ms. Blanche, anything else?
I feel like I'd just be belaboring all the points I made before, but I am, like I said, concerned with community safety based on the fact she was last seen with him. She's found dead, and he's tracking up to Northfield. That's a huge concern. And even if it came back that she overdosed, he didn't even call. If that was, let's say that was the benefit of the doubt for best case scenario. He didn't call for medical. He did nothing. He dumped her body on the side of a road up in Northfield Township in our jurisdiction. So even if that was the case, nothing was done to help this person that was in his supervision at that time that he was with her. So even if that was the benefit of the doubt and that was the argument, that's what comes out, that's still, I mean, the fact that you're lying, making misrepresentations to the police, lying to the police, and then this woman's found dead in our community. Honestly, Judge, a $2 million bond is not unreasonable under the circumstances.
I believe we are set for a PCC next week on the 25th. Okay, here's what I'm going to do, and I'm doing this for a reason, mainly to inure to the benefit of the defendant in this case. I've heard the argument here. You can supply me whatever other information you want to supply to the court. I'm going to make my decision. I'm going to move the PCC to 3:00 on the 25th, if that will work with counsel's schedule. I will also set my decision on your bond motion for that same time. I want to mull over some things. I want to look at it. I'm doing that, and usually I don't adjourn my decision on bonds to another date. I will usually make that decision, but I want to look very closely at some things. I also want defendant to at least, defense counsel, to at least get a preliminary look at the initial discovery that's there, so that, and have an understanding of what the court may be taking into account with what the people have presented. So that's what I'm going to do. I don't, like I said, I'm not accustomed to doing that. And if I felt that absolutely the magistrate's decision on bond was an absolute abuse of discretion, I wouldn't hesitate to rule immediately. But I can't say that in my mind at this particular point in time with what I see. But I want to give you a chance to counter some of what the prosecution has put forth. I don't think that can be countered without seeing that discovered.
What I would ask maybe is if the court would consider lowering the bond to something that you suggested earlier, and then if I can supplement it, I will do that. But I'd like to give him the opportunity, at least at this stage, to try to raise some kind of a bond. So if the court would be willing to entertain that possibility, looking at it in the light most favorable to the prosecutor, set some kind of other bond that is currently set, and then if I can convince the court that
I don't think you, counsel, get what you're saying. I don't think you want me taking what I know now, looking at it
Okay.
with benefit to the prosecution. I really don't think I understand why you're saying that to me, but I don't think you want me to do that, because if I do that, I'm done. And I don't think I should be, because I want to make sure that everything that you have is given to me, and then let me make my ruling. People can like it, dislike it, but the one thing that you'll be able to say is that I looked at everything, gave everybody the opportunity to put forth everything before me, before I made my decision. And that's why I'm doing it this way.
Okay,
All right.
thank you.
So the 25th
Let me just,
at 3:00. And folks in the courtroom, thank you very much for the manner in which you conducted yourselves. The court does very much appreciate that, that everybody behaved. All right, thank you.
That's called the case of the people versus Farhid Jahar.
All right, this is the date time set for the decision on bond motion. Was there any additional information or argument from counsel?
yes, there is some additional information. If the court recalls, at the last hearing, I said, we don't know what the cause of death is. It could be, yes, it could be homicide, but it could be a drug overdose. If the court recalls.
I recall.
Two things that I would like to update the court on. First, I was puzzled by the medical examiner's statement that Ms. Blanche was kind enough to forward to me, where she said it's consistent with homicide, but the manner and cause of death may never be known. Those two statements, to me, can be reconciled. So I actually called the medical examiner and spoke with her. And she said to me, I'm not going to talk to you about this because I don't have anything final. And I said, well, I saw the email that you sent to Ms. Blanche. And she says, well, that was a private email. Judge, I don't think it's the business of a medical examiner to be sending private emails not to be shared with defense counsel. But Ms. Blanche understood ethically that she was required to do it, and I commend her for that. So I don't have any more information, but she certainly couldn't explain how those two statements can be reconciled. But more importantly, Your Honor, I got the discovery. And the discovery, I'd like to read to you a portion of it. It's not very long. What was not in dispute in this case, or I don't think is in dispute in this case, is that Mr. Haraj had two escorts at his house that on the evening of the 22nd, going into the early morning hours of the 23rd. And one of the escorts was a woman named Tatiana Perez, who lives in New Jersey. And the police department went to New Jersey to interview her. And I'd like to read to you what it says. Perez said they returned to Habibi's residence in Dearborn after dinner. Perez said there was another girl, Susan, and that's the deceased in this case, Susan. Perez said there was another girl, Susan, she knows, staying at the same hotel in Novi, and asked if Habibi wanted her to call Susan over. Habibi agreed to this and arranged an Uber to pick Susan up and to bring her to his house. Perez said when Susan arrived, the three began drinking and hanging out by Habibi's pool. Perez said they went into another room in the house, and that is when they started using cocaine. Perez said she does not use drugs and decided to leave. So what we do know, at least from the other witness that was present, is that Suzanne, the deceased, was doing cocaine, according to this. Could have overdosed, could have had a heart attack, so on.
But counsel,
And
I don't know if you want to make that argument, because depending on who supplied the cocaine, but certainly it being at the location, if it's that drug overdose that then results in a death, you got a whole other problem.
I recognize that. But the evidence in this case, the discovery, there is no evidence, and I mean, burden of proof is on the people or the prosecutor. There is no evidence that those drugs were supplied by Mr. Hajar. Nothing. There was a white powder found in a backpack belonging to, who I think belonged to Suzanne, although that's not quite clear, although the white powder did not test positive for cocaine. So I don't want to mislead the court. But the point that I'm trying to make, the burden of proof is on the government at every stage of the proceeding, although the burden of proof is lower at a.
But counsel, I don't leave behind my just common sense. I mean, I'm not sure or wise in everything in the world. Maybe somebody could tell me because I don't deal with escorts. So, I mean, I don't know if they bring their own cocaine. I would assume that that's not what happens.
But Judge, in all due respect, I mean, we're making an assumption where a man is presumed innocent, isn't even charged with this.
Counsel, this whole thing is full of assumptions. I mean,
No,
you're assuming it's a drug overdose. I don't know that.
I'm not assuming it's a drug overdose, but what I am saying to the court is the court was extremely concerned based on the evidence that Mr. Hajar may have been the one that committed if it was a homicide at all, and we don't even know that he was responsible for the death. But there's no.
Certainly that becomes a question, but to say I was overly concerned about that, here's what I have, counsel. I have his phone at the scene where this body is.
I'm not disputing that.
I have this woman, along with another woman, as I'm to understand it, that goes into his house. Her phone, the deceased phone, is pinged to his location. And then it's time also to understand nothing else after that. So there is certainly a whole lot that can be made up in there or assumed to be, but I got somebody that's dead. The last place I had that person is his house. That's what I got.
That's what you've got. I'm not disputing any of that, Your Honor. And that's why when I filed this motion, I didn't ask for a personal bond. I asked for a $100,000, 10% bond because the defendant has not been charged with a murder, but recognizing that there are circumstances which might lead one to believe, although he's presumed to be innocent, that somehow he was involved in a homicide. But there's no evidence at this stage that it was a homicide. And I'm not saying, Judge, and I maybe I'm just not making myself clear, but I'm not saying that it shouldn't be some kind of a cash bond, although the presumption in Michigan is to give a personal bond. But a $2 million cash or surety bond where he has to pay a bail bonds person $200,000 that is not refundable. If the court believes that a $2 million bond is appropriate, which again, in all due respect, I don't think is appropriate, then it ought to be at least a 10% bond. There's a case that the court may be familiar with, and that is People versus Reginald Davis. This is a case where the defendant was actually charged with murder, and the judge allowed him to be released on bond. The Court of Appeals reversed it because the statute says that bond shall be denied where the proof is evident or the presumption great. It then went to the Michigan Supreme Court, and the Michigan Supreme Court remanded it back, saying that's inconsistent. Is that inconsistent with the court rule and with the Michigan Constitution that says may be denied? Ultimately, the Court of Appeals ruled that a defendant can be admitted to bond even where the proof is evident or the presumption great. And that's a case where he was actually charged with murder. The court does not say what the bond was in that case. But in our case, and the court said bond ought to be reasonable. That the court ruled. So what I'm saying, Your Honor, is I'm not asking this court to release him on a personal bond. It's obvious to me, and I've been doing this long enough to read the tea leaves, that this court is not going to grant a bond that I've requested of $100,000, 10%, but a $2 million cash or surety bond where the defendant has not been charged with a homicide. It's not even clear that it was a homicide. I just think that that bond is unreasonable. So if the court made it a 10% bond, at least they could post it and maybe get some of it back at some point. But I also want one other thing. If the court will recall, if you look at all of the factors that are set forth in 6.106, one of them is a third-party custodian. I introduced the court to a former Detroit police officer who has known Mr. Hajar since they were in high school together. He said he would act as a third-party custodian. He's a retired police officer, but there's nothing in Mr. Hajar's background that would indicate outside of this offense that he has ever had any tendency towards violence. And I just think that while maybe a substantial bond, if the court feels it's appropriate, so be it. But $2 million cash or surety, I think, is excessive in violation of the Constitution. I've said my piece, Your Honor.
You would agree that reasonableness would also have to be balanced against one's means.
Correct. And if he had a $200,000, he'd be out by now, Judge.
So do you want me to go through and just pull all of his financial records and anything that he's attached to in order to make a proper determination of reasonableness? I mean, that's what's going to happen. I mean, if I take your argument, that's what has to happen.
If the court was prepared, if the court wants his financial information, I'll supply it. But again, if we talked about this, Your Honor, that I said that really whether he pays a bail bondsman $200,000.
Counsel, let's be real about this. Okay. Because I think if I take the financial things, my understanding is he's tied to 11 different businesses.
He works for, that's his main business.
Whoa. But that he has interest in 12 other companies or 11 other companies.
I don't think that's accurate, Judge. He has his own, he has a business on the side where he does IT work. There's one other business. And at this time, it's not even showing a profit. And if the court wants to put him under oath, subject to the penalties of perjury, so be it.
I don't need to do that to set a bond, counsel. You're really making this a whole lot more complicated, I think, than it need be. But I mean, I'm willing to go there if that's what you want me to do.
Well, what I would really like, Your Honor, is if you could make it a 10% bond.
I know. That's what you would like.
That's what I would
like. And the
like.
people object.
That's right.
And that is where I'm trying to balance where I land on that.
Correct.
And I can only get there by what I see in the case, what risk he would pose to leave or what risk he would pose to the community.
But he would be on a GPS tether. And if the court requires him not to live in his house and to live with Mr. Garza, he's prepared to do that. I've spoken to Mr. Garza and he said he would put him up. But again, I just keep repeating myself, Your Honor, but the point that I'm trying to make is there is no evidence at this stage that there was a homicide, that the cause and manner of death. So what you're looking at is a guideline range of either 0 to 17 or 10 to 24 at tops at this stage. If he's charged with murder down the road, then of course the court would have the option, if the proof is evident or the presumption great, to deny bond and remand him. But at this stage, for these charges, even given what you characterize as suspicious circumstances, I think a $2 million.
Quit, counsel. You need to stop with what I'm characterizing.
With
I am just laying out what I know. That's all I'm doing. I'm not giving weight to anything at all. I'm just laying out what I know.
Right, but I think the court is concerned about the safety of the community because of the circumstances.
Anytime there's a dead body and somebody's around a dead body, yeah, darn it, I'm a little bit concerned.
Right, and understandably so. And that's why I don't expect the court to release him on some nominal bond. But $2 million, 10% is not a nominal bond. That's a substantial amount of money. And if the court wanted him to, in addition to that $200,000 10% bond, to post a house where he lives, we're prepared to do that. That gives some surety in addition. And he's only facing at this stage a charge that carries a maximum of 24 months under the guidelines. We live in a country where a person's presumed to be innocent, and there is no evidence in this record at this stage that this was a homicide, other than a statement that seems to be contradictory, consistent with a homicide, but I don't know whether we can ever determine the cause and manner of death. Judge, I've been beating a dead horse, which I said the other day, but again, if the court does not feel that something less than a $200,000 10% bond is appropriate, so be it. But I think that's a reasonable, fair bond under the Constitution.
Anything from the people.
Yeah, just briefly, I just want to make the record correct on the fact that the medical examiner didn't email me. I actually received the email through my officer, so she wasn't emailing me and saying, don't share this with the defense. That wasn't what happened. She shared it with my sergeant and he sent it to me. So I just want to make the record correct on that. And he's right, this is not a homicide. That's why I'm not asking the court to deny the bond. I'm asking to set a bond. We had asked for $10 million to begin with. And under reasonableness, he's saying they can actually post this bond. They just don't like the fact they're not gonna be able to get the money back. Which if you're making that statement, then how are you saying it's unreasonable when you actually can pay for it? You just don't like the fact that you're not gonna get the money back. I was quiet during your argument, sir. Can I please finish?
Sure.
Judge, when it comes to cocaine, he's relying on, he's telling the court that a independent witness had suggested that the victim had ingested cocaine that night. I don't want to try this case right now on the record. However, the defendant said there was no cocaine at the area. He doesn't partake in those drugs, and there was none there that night. So there's conflicting statements around whether or not cocaine was actually at the place. So to just blanket say that we have a witness saying that, well, the defendant said there was no cocaine there that night. And this backpack that he says belonged to the victim, she walked in with suitcases that night. The police asked the defendant for the suitcase she walked in with, and he doesn't know where they are. So I'm just concerned what's been kind of portrayed on the record.
Hold on. I want to make sure I understand that. Who is saying that she walked in with suitcases?
There's video showing her walking in with suitcases because she left the hotel, came to his house, and then the suitcases are gone. Judge, I don't believe the bond is unreasonable in these circumstances. I'm not asking you for the $2 million based on the fact that, this is a homicide right now. I'm asking based on the fact of defendant's misrepresentations to the police that night, the fact that we have a missing woman last seen going into his house, never coming out, and then his car going up to Northfield Township, and she's found dead in the place that his car was at. That alone, those circumstances, I believe that he presents extreme danger to the public, and I believe based on that, you can rule $2 million for his bond, and I don't believe it's unreasonable because he's already said that he could post the $200,000 to 10% to a surety bondsman. So I don't know how you can make that argument, Judge.
I can tell you exactly how I can make that argument, because a bail bondsman requires collateral for the rest of the money. So they'd have to post collateral of $2 million. They don't have that. That's the problem. If it was just the 200,000, it may not, they could raise it, although I think it's punishment to have to do a non-refundable 200,000, but the bail bondsman requires surety such as a house. And that's $2 million because the bail bonds person needs to protect himself. No one's ever argued that he was a risk of flight. And again, this is a man who's in his 50s and has never been in trouble other than a 12-year-old drunk driving.
Counsel, what about the suitcases? What about his statement regarding the suitcases?
You mean his statement about the cocaine?
Okay. No, about the suitcases. I mean, so that's part of the problem here. Part of the problem here is that there's going to be all of these things coming out that are going to cut one way and or another. And so I was, at least for the purposes of this decision, satisfied to say there are certain misrepresentations to people that was contained in the people's motion. But now when I get down into the specifics of what those misrepresentations may be, that raises more concern for me.
I mean, because counsel, the witness you're talking about, you went through a lot of things about it potentially being something involving drugs. Then we find out, and you quote a statement about the drugs, only to find out your client's denying that there was ever any drugs. Then it just gets worse. I mean, at least in terms of my analysis of what risk he poses, because now I have that woman walking in on video with suitcases. She leaves there, the suitcases aren't to be found. They ask for suitcases, he doesn't know where they are.
There was one suitcase, it's not plural, but yes, the video
And
shows.
where's the suitcase?
Judge, I have not spoken to my.
No, but see, counsel, that's what I'm getting at. You want me to make an assessment regarding your client, the risk he poses. The more this stuff comes up, and when I ask the hard question, nobody wants to give me the answer.
I'll do my best, Your Honor. It's not unusual, at least in my experience, that people make false exculpatory statements.
I get it,
And
but they don't hide evidence. I mean, okay, that's the problem that I'm having now. Now, I come back today and there's this other added thing now. And that I think I can take into account in terms of the bond.
I'm not saying that you can't take that into account. It's never been my argument that you can't take those things into account. My argument is, Judge.
Counsel,
$2 million
tell me what I now do with now an indication that there is potential evidence that is missing, and a statement, I think, is at least an indication from people that your client is misleading authorities as to the location of that evidence. What do I do with that?
I'd have to go back and look at the discovery because I don't want to misrepresent what the discovery. I don't recall exactly what he was questioned about the suitcase, but I know it came up in the interview. I just don't have it in front of me. But let's assume that he misled, just for argument's sake, he misled the police about that. The bond in this case, if all of that is true, then still, I think a $2 million cash or surety bond is excessive and unreasonable.
No.
All I'm asking for, Your Honor.
Counsel, it might need to be more. If I come to the assessment that not only is he misleading authorities because he has the right not to say anything.
Correct.
That's one thing. But now when the statements are being made and he's misleading authorities and that it may look like certain evidence is also being secreted away someplace, that changes the whole thing.
How a suitcase would add or subtract from the strength of the case, I don't see it. But I don't have any answer.
It depends on what you think happened.
Again, Your Honor.
And then it would also depend, and it may not add or subtract anything from the case. But then you have to ask the question, if I have an individual that then is not, though the defendants necessarily have to cooperate with authorities, but that is then not turning over evidence.
There was
Counsel, that puts you into a whole other place. And you know that.
They did a search warrant on the house. They executed a search warrant.
No, but counsel, they know that something exists. They ask your client. They have proof that something existed when it went into that house.
That's correct.
They ask your client about it. Your client says that it's not there, whatever he's saying. You know that puts any argument that's being made from any court's perspective in terms of reasonableness of the bond, that puts it in a whole different light.
Judge, I made my.
That's what I'm saying. It's getting worse.
But you have to factor into that. I also have somebody that it is also alleged as lying to authorities, who also is having evidence that they're not turning over to the police and or have secreted in some way and or destroyed. It doesn't go one way, counsel.
And I'm not saying it does go one way. All I'm saying, Your Honor, is $200,000 is a substantial bond. He's not charged with murder at this point, and they haven't even shown that it's a homicide at this point. And it may be quite some time before that happens, and he sits in jail on a case that has, at worst, 10 to 24-month guidelines. That's my argument, Judge, and I don't mean to keep repeating myself.
Anything else in the people?
No.
Court's going to stay in recess. Everybody can remain seated. Back on the record. The court has reviewed the Court of Appeals case and read over the Court of Appeals cases provided by the defense. Let me first say, as I said at the end of the last hearing, I do not believe that the bond is set by the magistrate, at least based upon the information that the court had at the time, that this court had at the time, that this court could constitute or say that that was an abuse of discretion. What is notable in the defense's argument, and all of it certainly being legally correct, but then again, taking those arguments and applying them to particular factual circumstances, at least as the court would know them at this time, maybe where there is some difference. Notable is the defense's statement that the $200,000 that may be required to pay a bondsman, that could be accomplished, but that then there is that the real crux of the issue is that should everything go forth through trial, through everything, where there would then be a release of that surety, that the defendant does not get that back, or the monetary funds back. That is correct. But they're also not having to put up the entirety of the $2 million. But what's notable in that is that the $200,000 could be indeed posted. The more the facts are laid out before this court, the more the court has not just questions, but certainly has concerns about safety to the public. I don't doubt that there are individuals at basically a full courtroom, the last hearing, that there would be individuals who would vouch and that the defendant could be released to. That isn't really the court's concern. What is of concern to the court is that as this is ongoing, the risk, the danger, as it is uncovered as to maybe what occurred in this case, would lead the court maybe to a different conclusion as to the defendant's danger to the community and the threat that he may pose. By way of example, certain facts today, some of them laid out in generalities, but not in specifics, were not known to the court just last week. And they do give this court great pause. And I don't think it unreasonable for this court to take into account what may be statements made for the purpose of misleading an investigation and or the concealment or the destruction of potential evidence in the case. One of the reasons why I wanted is counsel were going through everything last week, that the defense at least be presented with or have the discovery in case those arguments were made. That having been said, the court is going to rule in this case that the bond is set by the magistrate. As I've indicated, I don't believe is unreasonable. I do not believe, under the circumstances, I do not believe that it is unreasonable. I do not believe that it was an abuse of discretion in terms of the magistrate in setting the bond. To be quite frank with you, given what I learned today, it might lead this court to think that a higher bond might be required. But I'm not going to do that either. I'm going to leave the bond where it is at $2 million, cash or surety, so that it can be posted. I will do this, however. Should the defendant not be able to post that bond, I would give the defense an opportunity to produce to the court certain financials, which I think the court, certainly under the court rule and otherwise, can take into account in terms of his ability, not necessarily to pay the $200,000 to the bondsman, because it's already been acknowledged by defense that they can do that. The question is the collateral that would frame up to $2 million. And the court would take a look at that and then reevaluate if bond cannot be posted. The court would then reevaluate and take a look at the bond. I would also say, however, because of at least what the court knows or thinks it knows at this point in time, that as a additional condition of the defendant's bond, and I believe that the magistrate did order a GPS tether, I would order that if the defendant is released, he is to be a GPS tether is to be placed on the defendant prior to his release. Indicated also he would have to surrender any passport or any other documentation which would permit him to travel outside of the United States. Additionally, as part of this court's order, given what I've seen here, that should there be enough evidence at some point, and this will be a condition of his bond, that if there be enough evidence that the people would file and charge the defendant with open murder, first or second degree murder, or any other type of homicide type of an offense, that the defendant bond as set would be canceled, and he would then have to surrender himself immediately to the Washtenaw County Jail if those charges were to come about. And that would, as indicated, be a condition of his bond in this case. That is the ruling of this court. Is there any questions regarding the court's ruling?
Would the court consider if we can post 2 residences that equal, let's say?
Counsel, I think I was very direct in my,
Okay,
that is.
I'm going to shut up, Judge.
If the bond as set cannot be posted, I'm giving the defense an opportunity to provide to the court financials that would lead the court in a different direction or to restructure his bond.
Thank you.
So with those conditions, defendant's motion is denied regarding a reduction or change in bond. I've given the opportunity for you to do other things and provide that to the court. I will look at it. I will diligently look at it. And if there's something that can be fashioned, I will do so.
I appreciate it, Judge.
If it's
And I appreciate the court's patience. It's been the longest bond hearing I've heard.
yes, and after 25 years sitting here, my longest one ever. So.
Your Honor, we would ask the probable cause conference to be put over 1 week so that we can see whether he has the wherewithal to post a bond under this current conditions or whether we need to present financial information. So that would be, let me just make sure I have that date open.
August 1st.
Pardon?
That would be August 1st. Record should reflect we had a brief bench conference in this case. Probable cause conference in this matter will be set August 1st, 2024, 9 a.m. Bond will continue in its dollar amount with terms as stated on the record.